If you are undocumented in Texas right now, the next 6 months will decide whether you get legal status or face deportation. If you are waiting for a green card, you might finally see your approval after years of delays. And if you entered the country illegally after January 1st, 2020, you are about to be locked out of the biggest legalization program in over a decade. 3 immigration reform bills just passed the U.S. House of Representatives in February 2026, and every immigrant in America needs to understand what just happened. This is not a proposal anymore. This is not a debate. The House voted, and these bills are now moving to the Senate. One bill gives legal status to millions of undocumented immigrants, but only if you meet strict rules. Another bill clears the green card backlog for workers from India and China, and the third bill expands ICE enforcement, increases deportations, and ends asylum parole at the border. Texas will feel these changes harder than any other state. We have the longest border. We have the second largest immigrant population in the country. And whether you are documented, undocumented, waiting for a visa, or living here on a green card, what happens in Washington over the next few months will directly determine your future. You cannot afford to wait and see. You need to know what is in these bills, who is protected, who is at risk, and what you must do right now to prepare. Let me explain exactly what just passed. The first bill is called the Secure Border and Interior Enforcement Act. This is the enforcement bill. It authorizes $32 billion over 4 years for border security. $12 billion goes to building new walls and barriers in Texas, Arizona, New Mexico, and California. $8 billion goes to surveillance technology like drones, towers, and sensors. And $12 billion goes to hiring 15,000 new Border Patrol agents and 8,000 new ICE officers. If you are undocumented and living in Texas, this means ICE will have more agents, more funding, and more power to arrest and deport you. The bill also eliminates humanitarian parole for most asylum seekers at the southern border. Right now, if you show up at the border and claim asylum, you can be paroled into the United States while your case is processed. Under this new bill, that ends. Instead, you will be held in processing centers on the Mexican side of the border or in third countries. Only after you pass an initial asylum interview will you be allowed into the United States. The bill also speeds up deportation cases. Immigration courts will be required to finish your case within 6 months if you are detained and within 12 months if you are not. That sounds good, but it actually makes it harder to win your case because you have less time to find a lawyer, gather evidence, and prepare your defense. Here is the part that affects green card holders. The bill expands the list of crimes that make you deportable. Before, only serious crimes like aggravated felonies could get you deported. Now, the bill adds a new category called crimes affecting public safety. This includes DUI convictions, domestic violence misdemeanors, certain drug possession charges, and even repeat traffic violations. If you are a green card holder and you were convicted of DUI 3 years ago, ICE can now put you in removal proceedings and deport you, even if you have been here for decades. Even if you have U.S. citizen children, you will have to fight your case in immigration court and prove that deporting you would cause extreme hardship to your family. Most people lose those cases. The second bill is completely different. It is called the Legal Immigration Reform and Backlog Reduction Act. This bill helps people who are trying to immigrate legally. The biggest change is the elimination of per-country caps for employment-based green cards. Right now, no more than 7% of green cards can go to people from any one country. This creates massive backlogs for workers from India and China who wait decades for green cards. This bill removes those caps entirely. If you are from India or China and you have been waiting years for your green card, this bill will dramatically speed up your case. The bill also increases the total number of employment-based green cards from 140,000 per year to 250,000 per year. This is huge for skilled workers in technology, healthcare, and engineering. For family-based immigration, the bill increases the annual cap from 226,000 to 350,000. It also creates a fast-track system for parents of U.S. citizens. Right now, parents can immigrate without limits, but it takes years. Under this bill, parents who meet financial and health requirements will be processed within 12 months. But here is the bad news. The bill eliminates the sibling category. Right now, U.S. citizens can sponsor their brothers and sisters for green cards. Under this new bill, that pathway disappears. If you already filed a petition for your sibling, you are protected. But if you have not filed yet, you will lose that option forever. The bill also reduces the diversity visa lottery from 50,000 visas per year to 30,000. The saved visas will be used to clear backlogs in other categories. There is also a brand new visa category called the Startup Entrepreneur Visa. If you start a business that creates jobs and generates revenue, you can get a visa that leads directly to a green card within 3 years. Texas, with its booming economy, will benefit enormously from this. The bill also requires USCIS to move to full electronic filing, online case tracking, and digital interviews within 2 years. Premium processing will be expanded to almost all visa categories so you can pay extra for faster processing. Now let me explain the third bill. This is the one everyone is talking about. It is called the Earned Pathway to Legal Status Act. This bill creates a pathway to legal status for certain undocumented immigrants currently living in the United States. This is not amnesty. This is not citizenship. This is a long, expensive, and difficult process that takes at least 13 years from start to finish. To qualify, you must meet 5 strict requirements. First, you must have lived in the United States continuously since January 1, 2020. If you entered after that date, you do not qualify. Second, you cannot have any felony convictions and no more than 2 misdemeanor convictions. Third, you must have continuous employment, be enrolled in education, or be a primary caregiver for a dependent. Fourth, you must pass background checks and biometric screening. Fifth, you must demonstrate basic English ability and knowledge of U.S. civics. If you meet all these requirements, you can apply for conditional resident status. This is not a green card. It is a temporary legal status valid for 8 years. During those 8 years, you must keep working or stay in school, pay all your taxes, not commit any crimes, and check in with immigration authorities every year. After completing 8 years in conditional status, if you meet all the requirements without any violations, you can apply for a green card. After you get your green card, you must wait another 5 years before you can apply for citizenship. That is a total of 13 years from undocumented status to citizenship. There is a faster pathway for dreamers. If you entered the United States before your 16th birthday, have lived here for at least 10 years, and graduated from a U.S. high school or got a GED, you can adjust to permanent residency after just 5 years instead of 8. That cuts the total timeline to 10 years. The application process requires extensive documentation to prove you have been here since January 2020. You need rental agreements, utility bills, bank statements, employment records, tax documents, school records, medical records, and sworn affidavits from U.S. citizens or permanent residents who can verify your presence. Many undocumented immigrants pay rent in cash, work off the books, or share housing without their names on leases. Proving continuous presence will be extremely difficult for many people. The fees are also substantial. The initial application costs $2,000 per adult and $1,000 per child. After 8 years, adjusting to permanent residency costs another $2,500 per person. Eventually, citizenship costs $760. A family of 4 could pay over $15,000 in government fees alone, not including lawyer fees or translation costs. During the entire conditional residence period, you cannot receive federal public benefits, no Medicaid except emergencies, no food stamps, no federal housing, no Affordable Care Act subsidies. You can work and pay taxes, but you cannot access the safety net. Only after you get your green card do you become eligible for those programs. Texas has about 1.7 million undocumented immigrants. If this bill becomes law, roughly 800,000 to 1 million could be eligible based on the January 2020 cutoff date. Cities like Houston, Dallas, Austin, and San Antonio have large undocumented populations who have built lives here for years. This bill offers a chance at legal status, but the path is long, expensive, and filled with requirements that will exclude many people. Here is what you need to understand. These bills only passed the House. They now go to the Senate, where the situation is very different. The Senate is narrowly divided, and immigration is one of the most divisive issues in politics. The bills could pass unchanged. They could be amended with provisions added or removed. They could be combined with other legislation. Or they could fail entirely if they cannot get 60 votes to overcome a filibuster. Even if the bills pass the Senate, the president must sign them into law. The president supports immigration reform, but some enforcement measures may face opposition. Negotiations could result in changes before final enactment. If the bills do become law, implementation will not happen overnight. USCIS must write regulations, create application forms, build computer systems, train staff, and establish procedures. The conditional residence program would likely take 8 to 12 months after enactment before applications open. Border enforcement provisions would be phased in as funding is appropriated and personnel are hired. So what should you do right now? If you are undocumented and potentially eligible for the Earned Pathway program, start gathering documentation immediately. Do not wait for the bill to become law. Collect every piece of evidence showing your presence since January 2020. Request letters from landlords, employers, schools, doctors, churches, and anyone who can verify you were here. Make copies of utility bills, rent receipts, money transfer records, anything with your name and a date. Organize these documents chronologically in a secure place. If the bill becomes law and the application window opens, you want to be among the first to apply. If you have been paying taxes using an ITIN, make absolutely certain you file your 2024 and 2025 returns on time. Tax returns are one of the strongest pieces of evidence for proving presence and demonstrating good moral character. If you have not been filing taxes, start now. Consult with a tax professional about filing returns that document your work history. Avoid any criminal activity, no matter how minor. Even a misdemeanor conviction could jeopardize your eligibility. If you have old criminal cases that were dismissed, obtain certified court records showing the disposition. You will need those documents for your application. If you are in the United States on a temporary visa, be meticulous about maintaining your status. Do not overstay. Do not work without authorization. Keep your address updated with USCIS. The bills expand penalties for status violations, and even minor violations could affect future applications. If you are waiting in the employment-based green card backlog, particularly from India or China, this bill could dramatically reduce your wait time. Monitor the situation closely, but maintain your current status and continue with your existing applications. If you are a U.S. citizen planning to sponsor a sibling, file your I-130 petition immediately. The bill includes a grandfather clause protecting petitions filed before enactment. Filing now preserves your sibling's place in line, even if the law changes. Be extremely vigilant about immigration fraud. Whenever major legislation is pending, scammers multiply. They promise help with applications that do not exist yet. They charge fees for services they cannot provide. They take money from vulnerable people desperate for legal status. Only work with licensed attorneys or DOJ-accredited representatives. Never pay cash without receipts. Never sign blank forms. Never let anyone keep your original documents. The passage of these bills through the House is historic. For the first time in over a decade, comprehensive immigration legislation has moved forward with bipartisan support. Whether these bills ultimately become law remains uncertain, but the fact that they passed the House shows that political will for reform exists. For immigrants in Texas and across the United States, these bills represent hope, anxiety, opportunity, and risk all at once. The enforcement provisions create new dangers. The legal immigration reforms offer relief to hundreds of thousands. The earned legalization pathway provides a chance for millions to emerge from the shadows, though the requirements are steep and the road is long. Stay informed. Stay prepared. Gather your documents now. Protect your status. And understand that the next 6 months will determine your future in America. This is not the time to wait and see. This is the time to act.